Civil asset forfeiture is one of those practices that would be unthinkable if described honestly, yet becomes strangely acceptable once wrapped in bureaucratic language and justified in the name of public good. Under this doctrine, the government may seize a citizen's property, not after conviction, not even after formal charges, but merely on the suspicion that the property is connected to wrongdoing. The owner must then prove his own innocence to reclaim what was taken. This reversal of justice would have startled the founders, yet today it is treated as routine. The core problem with civil asset forfeiture is not merely that abuses occur, but that abuse is structurally encouraged. When law enforcement agencies are permitted to keep the proceeds of seized property, incentives are altered in ways that no amount of good intentions can correct. Institutions respond to incentives, not sermons. A system that allows police departments to fund themselves by taking property from citizens predictably results in more property being taken, especially from those least able to resist. Consider the case of motorists stopped on highways, particularly those traveling with cash. Large sums of money, though perfectly legal to possess, are often deemed suspicious by default. The money is seized, the driver released, and no criminal charges filed. The logic is circular. The cash is taken because it might be connected to crime, and the absence of charges becomes irrelevant because the seizure itself is treated as a separate civil matter. For many victims, the cost of hiring an attorney exceeds the value of the seized property, effectively rendering the taking permanent. Even more disturbing are cases in which homes, vehicles, or businesses are confiscated based on the actions of others. A landlord may lose a property because a tenant committed a drug offense. A parent may lose a car because an adult child used it unlawfully. In such cases, guilt is not individualized, it is collectivized. Property becomes culpable while people become secondary. This practice collides directly with foundational principles of American justice. The presumption of innocence is a moral declaration about the relationship between the citizen and the state. Civil asset forfeiture replaces this presumption with a presumption of guilt, forcing individuals to prove a negative, that their property was not involved in wrongdoing, often under opaque standards and tight deadlines. The Fourth Amendment's protection against unreasonable searches and seizures is similarly strained. Seizure without conviction and often without warrant stretches the meaning of reasonable beyond recognition. The Fifth Amendment's guarantee that no person shall be deprived of property without due process is likewise degraded when the process itself is so burdensome that justice becomes inaccessible. Defenders of civil asset forfeiture argue that it is a necessary tool in combating organized crime, drug trafficking, and corruption. But this argument confuses ends with means. The American legal tradition was deliberately designed to make law enforcement harder, not easier, precisely because the power to punish is also the power to oppress. In addition, large-scale criminal enterprises are seldom impacted by this policy. They can hire lawyers, use intermediaries, and exploit legal loopholes. It is the small business owner, the traveler, the immigrant, or the working-class family who lacks resources and political clout that bears the brunt of forfeiture. The result is not justice, but revenue extraction under the guise of law. History offers a sobering perspective. General warrants and writs of assistance, tools that allowed British authorities to search and seize property without specific cause, were among the grievances that animated the American Revolution. The founders did not merely object to abuse, they objected to the concentration of unchecked power. Civil asset forfeiture resurrects this power in modern form. It is worth noting that when agencies are required to place forfeiture proceeds into general funds rather than their own budgets, seizures decline. This is not evidence of improved morality, it is evidence of altered incentives. Remove the profit motive and behavior changes. That alone should tell us something essential about the nature of the practice. Justice, properly understood, is not about maximizing efficiency or revenue. It is about restraint. It is about recognizing that the government's power exists to protect rights, not to circumvent them. Civil asset forfeiture does the opposite. It treats citizens as potential sources of income and property, as a prize to be captured rather than a right to be respected. A society committed to liberty must judge its institutions not by how they perform at their best, but by how they behave at their worst. Civil asset forfeiture fails that test. It invites abuse, rewards overreach, and erodes the moral foundation of the legal system. If property can be taken without conviction, then rights exist only at the pleasure of the state. And that is a principle wholly incompatible with the American idea of justice.
Can you say why America is the greatest country in the world?
Freedom and freedom. So let's keep it that way.
I think that the real job that we have that confronts us is to somehow be able to sell our fellow Americans on the moral superiority of personal liberty.
I would remind you that extremism in the defense of liberty is no vice.
Once justified in the name of public good.